Good afternoon. Welcome to this Diversity CLE program sponsored by the Iowa State Bar Association's Diversity and Inclusiveness Committee and the ISBA's Civil Rights and Public Interest Law section. I'm Emily Chaffa, co-chair of the Diversity and Inclusiveness Committee. Our presenter today is Henry Hamilton III, current chair of the ISBA Civil Rights and Public Interest Law section.
Thanks, Emily. You're always so kind. I much appreciate it. Also, appreciation to the Iowa State Bar Association for giving me this opportunity to talk about these important issues surrounding the erosion of our rights, constitutional protections, and our American values. It's happening and it's happening now, and that's why I'm also appreciative of having this opportunity. And of course, folks that want to get more involved in these issues, I encourage you to join the new ISBA section of Civil Rights and Public Interest Law. We're looking for some good workers, also looking to be educated. With that, I'll go ahead and get started. As the title, not the title, but some of the marketing materials implies that African Americans, immigrants, members of the LGBTQ+ community, individuals with disabilities, women and child laborers are experiencing some of the most significant rollback of civil rights and constitutional protections in nearly a century. And this isn't just hyperbole. You know, it's always been anywhere from difficult to dangerous to be perceived as different in at least the United States and sometimes Iowa. But what we're seeing now is a revival of the sort of systemic and orchestrated hateful legislation and government actions directed at some of our marginalized communities in Iowa than we've seen in 3/4 of a century. And so today I'm going to talk about the latest attacks on African Americans, immigrants, members of the LGBTQ+ community, individuals with disabilities, women and child laborers, and probably not in that order, but I think what I'll do for each of these is I'll briefly talk about where we started, the progress we made, and then where we are returning. And with that, I'll talk about African Americans, and a lot of us are familiar with this, particularly the ones that do a lot of civil rights work in Iowa. But, you know, the Supreme Court starts out in our early history fairly progressive. The other branches of government, not so much. You know, you have the Henry Ralph case where the Iowa Supreme Court held that Iowa was a free state and anyone that makes it to our soil is thereby free. But at the same time, you have the Black Codes, and I'll call these Black Codes 1.0. In 1839, the legislature required African Americans to post a $500 bond to settle in the state of Iowa. I haven't calculated what that would be in 2025 dollars, but you can imagine that was quite a price for the free African Americans, and definitely a price for the formerly enslaved African Americans who had their wages stolen for decades. It was we also had the fugitive slave clauses. In 1851, we prohibit altogether free African Americans from entering into the state, period. We also forbid African Americans from giving testimony in any case where a Caucasian was a party. On the good side, in 1851, we do become one of the earlier states to disallow the bans on interracial marriage. Early on, the African Americans were prohibited from practicing law. That changed in 1870. And 1870, of course, that was the year after Arabella Mansfield was sworn in as the first woman to practice law in the United States. And the following year, the Iowa legislature struck the words white male from our attorney practice statute, and African American males were allowed to practice law here in the Iowa. Significant cases, you know, Iowa early on established in this state that separate was not equal. You have Clark versus the Board of School Directors in 1868, where the Supreme Court held that school districts could not discriminate on the basis of race in school selections. You have Koger versus Northwestern Union Packet Company in 1873. That's where the young lady was forcibly removed from the common carrier, and she sued for damages, and the owners of the common carrier said she was seated in the wrong place, and the Supreme Court allowed the conviction stating that we could not separate by race. We have 1884, the Civil Rights Act is passed. Enforcement wasn't the greatest, and it was narrowly interpreted. In about 1949, we see some strength from the courts to support the Iowa civil rights, and that's where Edna Griffin attempted to be served at Cat's Diner downtown. I think there's a marker down there, probably about 7th and Locust, if I'm not incorrect. And the owner was charged with a criminal conviction, and the court upheld that conviction. So that's where we were. 1965, we have the Civil Rights Commission established, and it gives protections to protected people in many categories for housing, employment, and public accommodations. So, but then we fast forward to the most recent time, and a lot of this activity has taken place since 2016 in the last 10 years, and I call this Black Codes 2.0, because some of these activities are directed at African Americans and making them feel unwelcome, or at least being able to enjoy their experiences here in Iowa, and prohibiting their contributions and experiences from being experienced by others. In 2023, the governor signed Senate File 560, which required the state public universities to cease all hiring related to diversity, equity, and inclusion. And this year, we have House File 856 that you probably heard about, that's been in the news. And not only does this restrict DEI at the public universities, at the last minute, the private universities were struck from it, but it also gives a number of positions that the public universities cannot take, and the courts are going to have a lot of fun with this. Like so many pieces of legislation, it's pretty void for vagueness and hard and difficult to understand. For instance, university cannot take a position on unconscious or implicit bias, allyship, anti-racism, systemic oppression, social justice, district impact, or anything related to these concepts. And you can see the difficulties you're going to have that not taking a position on anti-racism. So a school is in the situation where you can't say you're for anti-racism, you can't say you're against anti-racism, and you can't say you're neutral on racism. And it's quite a pickle. And I want to discuss House File 802 at the same time. This was the law that was passed in 2021, which restricted how African American history could be taught in the schools. And I want to talk about those together just to show you the shifting rationales of the anti-DEI folks. So with House File 802, remember, a few years ago, the emphasis was on protecting children. We have to destroy the teaching of African American history, the teaching of slavery, to protect these poor, impressionable students across the nation, across the state. Well, now they've totally abandoned that, because now they've taken that rhetoric and they've taken it to our public universities in House File 856 and also Senate File 2435, which was passed. Senate File 2385 stripped the Iowa Civil Rights Commission of most authority to protect civil rights, and then also that law also struck a lot of the commissions that were set up in this state to study the history and the progress and future issues of a variety of marginalized groups. And I talk about that more when I talk about efforts to attack the rights of women later on. But let's remember that the Commission on the Status of Women had been around since 1969, I believe. Governor Hughes or Ray, I can't recall, established that, and in the legislature later on codified it in the state statute. It's been around for a long time. And I think at the time there was like 20 to 30 people on that commission. I know the Commission for African American Studies had about 12. So you've taken all of these commissions that studied how marginalized groups in Iowa were impacted, and you place it in the hands of, I think, a 9-member human rights board. Senate File 2435, that was the one passed a few years ago. And by the way, I'm putting together an outline. I have to go through and correct some typos, so you should have it this evening or the next evening where I talk about some of this stuff. But at the time, 2435 was called the most extreme anti-DEI law in the nation, and I have the site for that. It doesn't take effect until July 1st of this year. I don't recall top of my head whether there's been any litigation, but I want to bring this up because this is one of those laws that the Manhattan Institute ships around the country to see if it can pick up any steam. And it passed here, but the same law failed in Mississippi. And so what we have here is that professors at our 3 public universities, University of Iowa, Iowa State University, and the University of Northern Iowa, have more restrictions on teaching racism or anti-racism or allyship than professors at the public universities in Mississippi, which is quite strange because, you know, our public universities had African Americans going visiting their campuses since I think the 1870s, whereas Mississippi didn't even allow African Americans to go to their schools until the mid 1860s. So there's been quite a switch. This year we also have Senate File 311, which disbands the civil review boards. Back around the George Floyd when George Floyd issue was prevalent, the Iowa legislature, passed civil immunity for drivers striking protesters and enhanced penalties for protest-related crimes. And I don't know what those individuals have said about the January 6th insurrectionists, but I would hope that they remain consistent. Then we have a whole slew of state attorney general letters, a pretty prolific writer, writes companies that have no connection at all to Iowa, admonishing them for their DEI activities. There's been letters written to Fortune 100 companies, the nation's 100 largest law firms. At the time that this was written, I think perhaps we had one among the list, but not many. International shareholders in Glass Lewis. And I want to bring this up because what's fascinating is that in some of these letters, our Attorney General is quoting hate groups. Some of these groups have been characterized by the Southern Poverty Law Center as hate groups. Like, you get a chance, and these letters are, I'll put some links in my outline, but you can go to the Attorney General's website. But they quote, one second, ADF, Alliance Defending Freedom, and that's a group that the Southern Poverty Law Center describes as a far-right anti-LGBTQ plus group. And they go on to state, they say ADF's public relations and legal crusades are intertwined with Christian supremacist and white supremacist ideologies, characterizing diversity as a threat to white Christian men. ADF is working to dismantle DEI protections and weaponizing government regulations. And in these letters, she also, our Attorney General also has she's against DEI because she's for merit factor selections. And I don't think many people on the DEI, anti-DEI side understand that those are not mutually exclusive topics. For instance, we wouldn't even need DEI if in the past, women, African Americans, disabled people would have been able to participate in merit factor selections. What DEI is doing is increasing the umbrella, the universe of people who can participate in merit factor selection. But I'll have more on those letters. So that's where we are now. So you see the state very restrictive on the rights of African Americans, at least the legislature. We go through a period of more progressive relations with African Americans, and now you see this returning to a system where, quite frankly, well, let me put it this way. The folks from the Manhattan Institute, and this is recorded, they've been caught saying what their plan was. And the plan was, to take opposition to critical race theory, which reasonable minds can disagree upon, which I won't go into today, but reasonable minds can disagree, and then use that to foment opposition to DEI. And then once you foment opposition to DEI, throw everything under DEI that you care, and your supporters will be against it. So we've gone from opposition to critical race theory to opposition to DEI, and now we're participating in cultural cleansing, which is the destruction of a marginalized group's history, heroes, art, and we're seeing this. We're so far past this when you talk about taking down from websites information about African American heroes, or defunding libraries that have the audacity to have books about the African American experience or the LGBTQ plus experience, firing librarians, defunding museums that dare have artifacts reflecting African American culture and experiences, or LGBTQ culture and experiences. I want to now talk about immigrants, and Iowa has a relation with immigration, has ups and downs. Early Iowans harbored a animus against immigrants, which stayed for a while until, of course, our neighboring states started attacking immigrants. And what Iowans realized was that the immigrants were coming over with money. And so then Iowa began an aggressive campaign to attract immigrants so they could compete with other Midwestern states such as Illinois, Minnesota, Missouri, and others. For instance, in 1856, Wisconsin had attracted 10,457 foreign-born residents. Those residents brought with them $1,045,661. At the same time, Iowa had attracted 1,855, barely a tenth of what Wisconsin had attracted, and their assets, the money they brought with them was close to $250,000. But to reap the benefits of the foreign-born populations, Iowa began an aggressive campaign to recruit foreign-born residents. So let's skip forward now. In the outline, you're going to see materials on the English-only laws and the voting materials. And around 1918, we started establishing English-only laws, mainly to disrupt the Germans who were here. The law was scaled down after the war. There's a famous case of Bartels that went to the Supreme Court, and the Supreme Court held we couldn't have these English-only laws. Then you skip to the 1990s and you have State Senator Steve King. He began sponsoring bills declaring English as the common language. These bills failed, but in 2002, the Iowa General Assembly passed and Governor Vilsack signed the Iowa English Language Reformation Act, proclaiming English as the official language of Iowa. Now, the problem was at the same time, Iowa had an administrative code which provided that the Secretary of State could provide voting registration forms in a different language. So at the time, Governor Chet Culver and the Iowa Secretary of State, Michael Morrow, continued to provide these forms in different languages. The matter went to the District Court of Polk County, and after they were sued by Senator King and then the auditor of Montgomery County, Iowa, now U.S. Senator Joni Ernst. They were sued for distributing these matters in a second language. They were sued. The court enjoined them. You skip forward to 2021. Secretary State Pate continues to distribute forms to folks who are Iowa citizens, but nonetheless, English is not their first language. He's sued. This matter is still being litigated. I have it in my outline, but LULAC sued Pate to begin issuing voter registration forms in a language that voters could understand. We also have the harassment of immigration lawyers that's taking place. The Iowa Migrant Movement for Justice is a statewide membership-based advocacy group, and they support immigrants. They were recently sent a threatening letter by the chair of the Iowa House of Oversight Committee requesting the names and salaries of all of their employees, requesting a description of all legal services provided by IMJ, with a list of such services and the persons to whom these services were provided. Now, these are lawyers representing their clients. So imagine if you and your practice received one of these letters, and then the current membership list for IMJ. And that's in the outline. Senate File 2340, this was the bill that made it illegal for an undocumented worker to enter Iowa after having been denied admission, excluded, deported, or removed from the United States previously. That, I believe, has been enjoined. I'll come back to that later. That's in the outline. Recently, Attorney General, in 2018, Governor Reynolds passed Senate File 481, which required local law enforcement to cooperate with the federal officials in federal immigration enforcement. This year, apparently the Attorney General went on Facebook and saw that the Wenatchee County Sheriff had placed a post on Facebook that the Attorney General thought was encouraging interference with state laws, and she brought an action. I don't know what's going on with that, but I bring this up because we've been here before with, I started talking about the black codes, where we tried to restrict African Americans from coming to the state. And then once they were here, we codified in law, essentially, that you could harass and discriminate against them. I bring this up because people, this is happening, and it's happening now. And I think as lawyers that we should be cognizant of some of this stuff. But I do want to say what was going on at the time. Samuel Kirkwood, who was a governor and former senator, he was asked about the question during a debate with Dodge in the election, the 1860 election, and the question of the fugitive slave law came up. And Kirkwood, our future governor, says, quote, "I would not resist the enforcement of that law, but before I would aid in capturing a fugitive slave, I would suffer the penalty of law. So help me God, I would suffer my right arm to be torn from its socket before I could do such a thing." Okay, so you see where we're going there with immigration. I want to talk. Well, I'm running, but how much time do I have? An hour left? No, this guy is kidding. That's a joke. Little humor, little CLE humor there. Oh, great. I'm going to talk now about the issues facing the LGBTQ plus community, where we were and where we've come from. I think in doing this research, and maybe some other folks were aware, but it's interesting how far we've come in the state, but at the same time, we have so far to go. And I think what's important to remember here, these issues are not new. Because our history books are taken away or manipulated, we don't know about the full diversity of America, but there were same-sex activity taking place in the colonial times. And even before, there was same-sex activity taking place with Native Americans. There was same-sex activity taking place in the colonies. There was same-sex activity taking place among the enslaved population. And think of it, I mean, these ships are coming from England to the United States. There's 3 to 6 months voyages, and yes, there's same-sex activity taking place on those ships. This is not new. We've been through this as a country before. Even cross-dressing is not new. We've had cross-dressers since very shortly after the first ships hit our shores. In fact, we have a famous case in Iowa of Safrana Hunt Smith, who was a cross-dresser, and not so much for sexual purposes, but she wanted to fight in the Civil War. And so she dressed as a man, and she served in the 29th Infantry in Iowa. And so there's a well-known story about that. And the history books show that there were 400 women that did the same thing, pretended to be and dressed as men to serve in the war. So when you get this stuff to panic over some of these issues, don't necessarily buy into it. And now, In colonial times, not a lot, but you had women that cross-dressed because men had more rights, or I should say, for lack of a better phrase, more access devices. Women couldn't spit on the sidewalk. They couldn't chew tobacco. They couldn't gamble. They couldn't swear. They couldn't drink. They couldn't stay out late. And so not a lot, but there's a pretty good number of women that cross-dress to have some of these rights and privileges that were granted to men. But the big one this year, in the outline, I talk about our history of criminalizing and uncriminalizing sodomy. I also talk about our dark past. I guess it started out being unsexing, but our dark past of sterilization and how far we've come from those two practices. Moving today, though, of course, we're all aware of Senate File 418, which eliminated gender identity discrimination and essentially grants individuals immunity if they want to harass or discriminate against people based upon their gender identity. The same law also takes the term equal, does not mean same or identical. That would be another 20 minutes. Separate accommodations are not inherently unequal. That's in our code now, probably ignoring, 150 years of Iowa law and 70 plus years of federal law. This law also requires birth certificates to reflect a person's birth at sex as either male or female. It strikes a section from the current law that would allow a transgender person who transitions to receive a new birth certificate. And we have a lot of folks in the state that are keeping track on these issues. Too many to name, but I do want to give a shout out to Lavender Legal Clinic for their work in this area. And it's important, I've been advised it's important to remind people that they have until July 1st to change the gender markers on your Iowa birth certificates. After that, you will not be able to do that. So if that impacts you, your family, friends, neighbors, or clients, I wanted to get that out there. And also, Lavender Legal Clinic was recently given a grant from Johnson County to pay for court filing fees in Johnson County. So residents there can affect their name changes. So you want to Google that and look up that. I'm going to skip ahead. We have same-sex marriage. We're all familiar with Barnum v. Bryan and Obergefell versus Hodges. This year it didn't get much traction, but this stuff, can come up. We had Senate Concurrent Resolution 3, which starts out or states that court rulings are not laws and only legislators elected by the people may pass laws, and is calling upon the General Assembly to send a message to Congress and I believe the courts for to reverse these same-sex decisions. It hasn't picked up much traffic yet, but the legislature doesn't meet again until January, so we want to keep our eye on that development. Emily, how much time do I have? How much time do I have? 15, okay. As far as women, like the African American I talked about earlier, and this is in the outline as well, the earlier Constitution had several restrictions against against females that prohibited them from enjoying the rights enjoyed by females. In 1987, Iowa passed a gender balance bill for appointed bodies. And of course, that lasted 37 years. in 2024, Governor Reynolds signed Senate File 2096, which repealed gender balance requirements for appointive bodies. I talked earlier about the Iowa Commission on the Status of Women that was started by Governor Ray in 1969, formalized into law in 1972. In 2024, the Commission and Office of the Status of Women was eliminated, and it's now, I believe, is under the Human Rights Board. But remember, I talked about that earlier. I talk about the right to bodily autonomy, and the outline some early laws, which at first were strictly prohibiting a person's right to bodily autonomy, particularly females. I take us through the history of that and the recent legislation and case law and the impact on that important right. For the disability community, so the Biden administration had attempted to add gender dysphoria to the definition of disability under Section 504 of the Rehabilitation Act and the Americans with Disabilities Act. Several attorney generals filed suit, but the alarming part is in that suit, they've asked to have Section 504 declared unconstitutional. And that's in their prayer for relief. Now, there's been talk in the press that they're not pursuing that anymore. But yet again, I don't believe it's been deleted from their demand for relief. So we got to keep an eye on that development. We have a recent history of being more and more progressive in supporting the rights of individuals with disability. It would just be terrible if that was interfered with. Someone did notify me that Disability Rights of Iowa has recently settled a lawsuit that will bring additional services to children for their mental and mental needs. And so real briefly, that's where we are with these groups and where we've been and where we've come from. And if I wasn't articulate enough today, I think when you get the outline, you'll see that it's happening now. We're engaged in this systemic and orchestrated scheme to target marginalized groups. And that's where we are. And so I hope that folks will take action, if it's nothing else, than joining the ISBA Civil Rights and Public Interest Law section. I do want to spend some time talking about the cost of these anti-DEI measures. And I'm not saying there's a cause and effect here when I mention these issues, but it's something to think about. And it's also, why are we paying so much attention to DEI when we have these other concerns? But the Iowa Legislative Services reports that Iowa's economic woes are increasing, where the nominal gross domestic product in the United States increased by 5.3% in 2024. Iowa's GDP increased by 1.2%. Iowa's share of the U.S. GDP is currently its lowest measure since the current stats became available in 1997. And this is, and it's really decreased in 7 of the past 9 years. And that's about the same time we've seen this uptick in attention to DEI. And CBS News reports that Iowa's economy is now the second worst performing in the country. Iowa ranked 48th in personal income growth at 2.4%, ahead of only Nebraska and North Dakota, and had the second slowest job growth nationwide in 2024, trailing only the Virgin Islands. It's also impacted education in Iowa. Iowa was historically ranked among the top 5 in the nation in education. Iowa has now fallen 20th to the 20th in the nation, and that's from the latest U.S. News and World Report ranking on education within the states, and that will be available in the outline as well. Healthcare is likely to suffer. I think we're all already seeing some of that as far as the consequences of some of this legislation. The Association of Medical Colleges, AMC, reports that states with strict abortion bans experience decreases in residency applicants. That is in the outline, and this is particularly troubling for Iowa, which already only has 3.3 OBGYN providers for every 10,000 women of reproductive age in the state, the lowest number of providers per capita in the country. And so we can ill afford not to have doctors continue to come to Iowa. At least one person says that these new developments could make it worse. As healthcare, at a cost of healthcare, period, there's been lots of studies, and I'll place one or two in the outline that focus on how racial and ethnic disparities cost our U.S. economy. And these figures are from 2021, I believe, but a doctor from the, where is he from? One second here. A doctor from the Department of Investigational Cancer Therapeutics at University of Texas, MD Anderson Cancer City in Houston, says that the racial and ethnic disparities in healthcare costs $451 billion for a whole slew of reasons. Also, the lack of healthcare workers. This one is very interesting. It's the only research that I've come across that has actually documented the actual dollar loss from anti-DEI legislation. And this is the Perryman Group that's been around for 40 years. Admittedly, I've never heard of them. I researched them. They seem to be well respected. They boast having represented 9 of the largest companies in the U.S., 8 of the 10 largest law firms in the country, 10 United States cabinet departments, 3 of the 4 largest foundations in the U.S., the 12 largest technology firms in the U.S., 5 large domestic financial institutions, and more than half of the Fortune 100 companies and 2/3 of the global 25. And they did a study of the potential economic loss from anti-DEI proposals in Kansas and Missouri. I'll list those in the outline, but some of the language is similar to the language that we have. And in Missouri, the loss up to, they're forecasting the loss because of these anti-DEI, from labor shortages to people just not wanting to spend money at places that don't respect their values, will amount to $2.6 billion in gross domestic product and 23,000 jobs in Missouri as of 2030. In Kansas, the loss is predicted to be $898 million in lost gross domestic product and 8,000 jobs. And you take that with the figures that I talked about before about Iowa's slow economy, last in the nation in this and that, and we can ill afford to have the kind of economic impact from anti-DEI efforts as the Perryman Group is forecasting in Kansas and Missouri and Kansas. So that was a lot. The outline almost turned into a book, but there's so much to cover. I do want to talk a little bit about strategy. And one strategy, like I said, is joining the civil rights section and the public interest law section, because we don't have all the answers. We need folks that are working in these areas. And I think, well, I'll get to that later, but we're thought leaders. As attorneys, we're thought leaders. And I talked about what's been happening, where we were, how far we've come, and then the going back on the rights and protections of all these marginalized groups. And as lawyers, being thought leaders, like it or not, when you raise your hand and you swear to be a lawyer, people in your community look to you as a thought leader. And we can't be silent when it comes to these issues, because our silence does two things. It signals acceptance of what is taking place, or it signals defeat. And since we're responsible, lawyers are responsible for the formation of our democracy and responsible for the preservation of our democracy, those are two messages that we don't want to send. So my building blocks, the 4 C's, and I think I might have an E in there, but the 4 C's. And the first is the most important. Well, we got comfort, collaboration, challenge, and courage. And maybe, I think the E came from educate, but I squeezed that under a C. But anyway, the first one is comfort, and this may be the most important. We have to comfort the victims of this assault on rights that have taken place the last 10 years. As politicians, they think strategies. As lawyers, we think strategies and positioning. These laws are actually impacting people today. There's 12-year-olds that may get pregnant and are going to be wondering what to do. There's people that need surgeries that may not be able to get these surgeries. You have a whole community of people now that are subject to discrimination with impunity. And I can go on and on and on. These people, at very first, they need comforting. And we need to tell them that we're on it, we're on top of it, and that we're going to try to move that needle back to common sense. The second thing is, the second C is collaboration. It's a big mistake to look at these laws or government action in isolation. I named 5 or 6 groups that are impacted. We can't remain in silos. We have to recognize this for what it is. And like I started the conversation with, it is revival of orchestrated and systemic attacks against the rights of marginalized groups that we have not seen in 75 to 100 years. And we can't fight these things piecemeal. We must recognize that and coordinate our efforts. And part of that is educating each other. As Emily told you, this is not my area of practice. I haven't brought a lawsuit in probably 30 years. But we need the folks to educate us. Like, what do I tell someone? They call and ask me for legal advice about a name change or their pronouns. We need folks from that community to educate the rest of us. What do we do if we're approached by ICE with an administrative detainer, not a court warrant, but an administrative detainer? We need to talk about these as groups. What do you do if you have a friend that was in the DEI office and all of a sudden has lost his, her, or their job? Are they still protected by retaliation? Title VII still says that that's protected activity. Do they have recourse? We have to come together and communicate better and collaborate. Challenge. We have to challenge originalism, misinformation, cultural cleansing, and we have to protect legal rights. These rights are not going to secure themselves. They never have. You can put words on parchment paper, or you can put words on code books, or you can put words, I guess everything's digital now, but those rights, they get the energy from activity. We need activity to protect these rights. Originalism. We have to attack this judicial philosophy whenever and wherever we can. I'm not saying it's not useful sometimes, but 95% of the time it's not, particularly the further back you go. With originalism, we perpetuate some of the isms that we had when the country was founded. I could take you through the populations that we had in this country at the time: the disabled, African Americans, Native Americans, women, members of the LGBTQ plus community. All these groups did not draft or have a say in the laws that were passed. Women didn't receive the right to vote until, Emily, 1919, 1920, 21? 1920. African Americans didn't have the unfettered right to vote until 1965. I stand here as the first generation African Americans who's had unfettered right to vote. We got to protect these rights. You already see there's backtracking on those. We have to have courage. That's the fourth C. All hands on deck. Those who can challenge should challenge. Those who can't should support those who can. You have to look at your own individual circumstance and determine what you're willing to sacrifice to promote these values. And I want to paraphrase civil rights attorney Ben Crump when he talks about how we lawyers always say how courageous we are, courageous this, courageous that, E-I-E-I-O. But he made a point of saying that courage means nothing if you don't display it in an unsafe situation. So look at your individual situation, but have some courage. And I'm going to end with speaking of courage, I'm going to end with one of the more courageous women that I know, individuals even, and that's Harriet Tubman, who made almost 24 trips to the South to help slaves escape. And she states, if you hear the dogs, keep going. If you see the torches in the woods, keep going. If they're shouting after you, keep going. Don't ever stop. Keep going. If you want a taste of freedom, keep going. Lawyers, I say, if we want to preserve freedom, we must keep going. Thank you. Thank you. Questions?
Thank you very much,
Okay.
Henry. There were a couple questions, and then I want to make one clarification.
Okay.
I guess when you were talking about individuals, well, basically women wanting to serve in the military,
Yeah.
and you used the word cross-dresser, I wanted to clarify. I'm sure what you meant is that was a woman presenting herself as a man, basically in her dress and her appearance.
Yeah. I don't know the
to
name.
make sure
Yeah,
that she could,
yeah.
well,
I think
to allow her to serve in the military
Yeah.
at that time.
Yes, she was
Okay.
placing she had a male uniform, and what's interesting, you do the research, what you point out is the difficulty of applying today's terminology to the past, because I'm not an expert in that area, but the terms, you know, where we equate sexual activity with a lifestyle really wasn't taking place in colonial times. That came up, and that's why I said same-sex activity, because those individuals didn't consider themselves lesbians or homosexuals.
Correct.
They were just engaging.
They were dressing in a certain way or presenting as a certain way so they could do something they couldn't otherwise do. Correct?
Yes.
Okay.
Yes.
Okay.
Yes,
That's what
yes,
I just want to clarify in case people are watching and like, why are you using that term? Because you're right. Terms change.
Yeah.
Here's a question. I've condensed the question quite a bit, but this is from a lawyer in I won't name the town, but an eastern Iowa small town that is 50% Latino because of industries located in that town. How can people in that town communicate, you know, the importance of basically the rule of law? Because you haven't really mentioned the rule of law, but all of these laws call into question, you know, some of the basic tenets of the rule of law. And then part of the question is, you know, how do we communicate basically that we all have skin in this game, whether we're individually affected by or impacted by all these laws or not, but the, you know, people we live with in our towns, especially so many small towns in Iowa, are more and more increasingly diverse. What would you suggest that lawyers do? Which I think this question was asked before you mentioned all the C's.
Yeah. Well,
but if you don't mind answering that question, or what you'd suggest to this small town, you know, rural area lawyer in a very diverse small town.
I just talked about 5 or 6 quote unquote marginalized groups. No single person has all the answers. We need to collaborate with each other. We're all being attacked, even the people that think they're not being attacked. I mean, when you take the autonomy over your body and you say that's a rational basis, well, sure, we think it impacts females, but that also impacts males. So now my autonomy over my body is given a rational basis. It's given rational basis scrutiny. So we need to collaborate, whether, you know, one of the best opportunities is the Iowa State Bar Association, the new civil rights section and public interest law. Come there, let's talk together, let's collaborate, let's communicate, let's educate each other. Like what you just talked about. Yeah, you know, let's educate each other. I've never represented, people in 4 of those groups, you know. And so I think that's one key, is the C that talks about collaborating and educating.
Thank you all very much. Thank you so much, Henry, for providing this plethora of information.